this is the rule, this is my power. I ordinarily do not make any comment of this nature. Simplest way, whatever the bureaucrats who have framed it, they saved their skin. I say
This channel does not promote or encourage any harmful or illegal activities. All contents provided are strictly for educational and informational purposes only.
cabinet হাতে কাছে থাকা উচিত। Is a part of supplementary affidavit, na? Yes. দাও রিট পিটিশনটা দাও, ওটার সাথেই আছে। সেট করা আছে, অন্য জায়গায় দেখছো কেন? Yes, it was very interesting decision. My lord, kindly come to the page 3 of the decision. I am not troubling my lord with the others. Page 3. Eight over the school. Page 3. No, not page 4. I will be page 3 of the cabinet memo. Got it? Yes, will I kindly come at the top, Mr. Roman 3. Roman, but I. The school education department also considered the proposal of Commissioner of School Education with regard to the demand of waitlisted candidates of physical education for appointment in their favor. It is failed to consider their demand favorably to instill confidence in the general public in the matters pertaining to education and involving public employment. Now, let instill confidence in the general public by not following the rules and constitution, but to quell the agitation. Then kindly turn the next page. What is the decision? The Commissioner of School Education at the top, third line. Got it? Page? Next page.
Supplementary page 6.
Page 6. Internal page 4. Yes, internal page 4. The Commissioner of School Education, the fourth line from the... Yes. Viday's proposal dated 4th May 2022 has proposed to create 1,600 numbers of supernumerary posts to absorb all waitlisted, to absorb. And then again, department's view. Creation, and will kindly come to II. 1,600 supernumerary posts for absorbing the waitlisted candidates. But I am noticing in nowadays the bureaucrats are a little more intelligent. To save their skin, they use proper words. They maybe are conscious that under what environment they are working. That we have said for absorption. And what would the absorption mean? Absorption means that they were already in employment. In whatever form they are. Now, maybe their appointment is not regular. They regularize their appointment like that situation. Therefore, the cabinet decision was to absorb. Creation of posts to absorb the persons who are working, but there was no post for them, no sanctioned vacancy. We create vacancy, which is oftenly faced by this court time to time. Now, what would really absorption mean judicially? Kindly, Miller takes Miller. Kindly 1991 supplemented to SCC.
1991 supplementary to SCC 553.
553. Now coming to the question of seniority, the term absorbed in service jurisprudence with reference to a post in the very nature of things implies that an employee who has not been holding a particular post in his own right by virtue of either recruitment or promotion to that post, but is holding a different post in a different department is brought to that post either on deputation or by transfer and is subsequently absorbed in that post, whereafter he becomes a holder of that post in his own right and loses his lien on his parent post. Therefore, someone who is already in employment, but he somehow or other comes to any department or place where there is no post for him, then creating a post to absorb him.
The supernumerary post can be created to absorb.
Absorb. So that someone whose employment is not thrown out because of departmental clashes. There is a preponderance of the probability that it may so happen. Someone was already working, but there was no post for him. He cannot go away. Therefore, create a post which is called supernumerary post so that the other persons who are in the card are not affected. But his personal service is protected. That's why the Supreme Court very categorically says, I am reading once again, in service jurisprudence. Coming to the question of seniority, the term absorbed in service jurisprudence with reference to a post in the very nature of things implies that an employee who has not been holding a particular post in his own right by virtue of either recruitment or promotion to that post, but is holding a different post in a different department, is brought to that post either on deputation or by transfer and is subsequently absorbed in the post, whereafter he becomes a holder on that post in his own right and loses his lien on his parent post. No one asserts that the instant one was a case of the absorbed sales tax inspectors being initially sent on deputation from the post of block level extension officer. This was vis-a-vis that particular case. I'm not troubling, my lord.
No, are you suggesting that the cabinet decision may be correct to absorb, but which cannot be applied to this to give appointment to them?
Cabinet decision would have been appropriate if they found that some people are already working.
No, if we take it that it was intended to absorb some.
Intended to absorb. Absorption means somebody is in employment.
So applying to it to the give appointment to the waitlisted candidate is bad.
No, I could take a different way. The authority knew that supernumerary posts can be created only for absorption, not for fresh recruitment.
Or the simplest way, whatever the bureaucrats who have framed it, they saved their skin.
I say they have saved their skin. But they also probably had matters of going on. The entire people in the world knew that these proceedings are going on. They also knew ultimately you may have to be. Now, Lordship has said that the then Honorable Minister in court says that I am not responsible. The officers are responsible. In the criminal court, that was a unique defense by the Honorable Minister that I, as a minister, do not do it. It is done by my subordinates.
Commission.
The other officers, they are responsible, including the commission.
Commission is responsible.
Therefore, absorption, Milord, I wanted to only show this, that when the cabinet memo is prepared and they categorically mention absorb, which would mean that the people were in employment. The next one is, Milord, in the same.
I'll be asking you to address on this point also. The commission was well aware of the rule position. This is the rule. This is my power. I have to conduct a selection test in terms of these rules. This rule prescribes that this is the procedure to ascertain the vacancy, beyond which I cannot do anything. Now, if this cabinet decision is taken on the suggestion of the commission, whether commission is at fault or who has suggested the Somebody has suggested the.
I placed in cabinet memo, it will be clear.
There are two
No.
There are
Whether commission is answerable to explain the situation.
all. But the commission says that I am bound because a direction under section 19 of the act is there. That is the plea also. Kindly takes up the School Service Commission Act. Lordship had discussed this cut now. Section 19 empowers the state.
Commission 97 Act of the
In the discharge of its functions, the commission shall be guided by such directions as may be given to it by the state government. Then this is important. From time to time, in conformity with the provisions of this act.
So, if a direction comes from the state, which is not in conformity with the act, then
What it
commission
requires-
can defy it or can.
Yes, legally they can, but it depends on that straightforwardness and uprightness. You are empowered, but the question is whether can you use it as a shield or sword.
This is an independent statutory body. It is expected that
Expectation, unfortunately, has thrown to Ganges. In one of the affidavits in another matter, I found that the present incumbent says that I am not going to take responsibility of the earlier activities. I have joined X date, and from X1, this is done, I am responsible. The institutional responsibility, institutional morality has been thrown to wind. Well, I'm very shocked to say these things. I ordinarily do not make any comment of this nature. This is a situation where the entire education's infrastructure is thrown to Ganges. And these are these effects.
so section 19 is the
Section 19, the government says I issue this direction, section 19, create supernumerary post and give them appointment.
This was the cabinet decision. Direction is part of this cabinet decision.
Yes. Now will I kindly come to the cabinet decision once again. Section 20, dissolution of the commission if the state government is of the opinion that the commission has failed to discharge its functions under this act. In accordance with the provisions of this act, the state government may, by an order published in the official gazette and stating the reasons thereof, dissolve the commission with effect from such date as may be specified in the order. Upon the dissolution of the commission under so and so, all the members of the commission shall be deemed to have vacated their office.
See, selection test is over.
It was over yesterday.
Yesterday. It
The
is over.
examination.
This 14th one examination was there.
Okay.
The written exam for 9, 10, 11, 12, that is complete.
Exhibition mein jana tha.
What else then?
The selection process is like that, so many things.
Manipulation, everything debates.
No. At this stage, that cannot be switched over to any other body.
No, that you do not do it.
That will create another chaos. No?
The judges of these courts are maligned every day. And I don't want to see that the other. You have already sufficiently maligned.
So, no, only I was inquiring, there is a power for the state government to dissolve.
Yes.
Therefore, the whole scheme of the act is a complete one.
It's a complete, watertight code, if I may use that expression. If you follow the statute, then there is a scope for any slipping of corruption. No. And you have to be transparent. Everything has to be transparent.